Good day and welcome to this new season, this new episode of Strictly Legal on WESN Content Capital. I am Rondell, Donawa, attorney at law, host of this auspicious show, and I'm happy to be back. This is the longest break we have ever had, but I'm grateful. And of course, we are back with new exciting episodes, and I'm looking forward, of course, to continuing the presentation of the law and you, and of course having my auspicious guests being present as we discuss various topics of public interest, as well as persons who would like information on specific areas of law. So once again, you can stream us on our social media platforms as WESNCC, as well as traditional media, and of course our podcast, Strictly Legal with Rondell Donawa. Sorry, I'm stuttering because I'm excited to be back in this studio. So without further ado, of course, we have an exciting packed program today where we will discuss the topic, when the abused becomes the accused, and this is a case of one L.C. For, of course, confidentiality reason. We will not release the victim or the accused and the accused name at this time. However, I'm excited to announce that I do have in studio Mr. Dinanath Ramkissoon, an attorney at law by profession who was counsel on this matter. And of course, I am pleased to just read a brief introduction of who Mr. Ramkissoon is. Of course, Mr. Ramkissoon has been marked by distinguished service and experience in law enforcement and legal practice. He began as a police officer, serving 25 years from 1975 to 2000. And after his tenure in law enforcement, he pursued a career in law and was admitted to the bar of Trinidad and Tobago in 2000. Now, throughout his legal career, Mr. Ramkissoon has gained extensive experience in the various areas of law. His notable positions include 4 years as a prosecutor at the Office of the Director of Public Prosecutions, as well as 4 years as an investigator counsel at the Integrity Commission, and also he spent a numerous amount of years at NITCO. Additionally, in 2016, he was appointed as a member of the Police Service Commission, where he served with distinction. Now today, Mr. Ramkissoon joins us to discuss his recent role as defense counsel in a criminal case that concluded in 2023. This case involved his former client, who pled guilty to manslaughter after spending time in prison for killing her abusive ex-husband. As part of this mini-series on gender-based violence, this episode today is entitled When Abused Persons Become the Accused. And we welcome Mr. Ramkissoon to delve into this complex topic as we discuss. Thank you, Mr. Ramkissoon, for joining us.
Thank you very much for having me.
Right, so of course, as I said, you were part of this case, this notable case, of course, that brought much public attention because of the intricacies and, of course, because of the type of matter that was involved. And just before we start the process of dissecting the matter and talking about real-life issues, particularly the failure of our institutions to protect both individuals, I would just like to read an excerpt from the judgment that was handed down by Justice Jeffrey Henderson on the 15th of November 2023. And based on his decision, what he stated is that in this case there were two victims. Of course, I won't call the name. So there was the deceased, who was the victim of a homicide, and the other person who was a victim of a serial intimate domestic violence at the hands of the deceased. What marks this case out as unusual is the death of the abuser at the hands of the abused. Now, what happens to make this case not unusual is that it is a textbook illustration of institutional failure to protect either victim from the predictable tragic outcome. Now, prior to this homicide, the offender was an estate constable and a person of good character, and the deceased victim, while clearly loved by his family, nonetheless a serial abuser. On the facts of this case, as accepted after her arraignment, L.C., as I will call her, was the victim of years of persistent and repeated verbal and physical abuse at the hands of the deceased, culminating in her frenzied stabbing of the deceased on the 11th of January 2017, resulting in his death, and her spending 6 years and 9 months in pretrial custody while awaiting the outcome of this case. And of course, it is notable to state that 6 years and 9 months in pre-trial custody, that is something, of course, has been a topic of discussion. And of course, we will speak about the delay in access to justice. So Mr. Ramkissoon, of course, if you can just, I know I would have given an excerpt from at least the overriding view of the judge. But if you can provide us an overview of the circumstances surrounding this case, including how you became involved as an attorney.
Well, I got a call from a former client who I represented, that he was saying that this case is unjust. Those are his terms, unjust. They should not have charged. And he asked me to represent the person. And I took it up, and the rest is history. But before going into the depths of this case, I just want to say it is a very, very difficult thing for judicial officers who have to make decisions on instances like these. Striking the balance between the public interests and the need to protect citizens, as saying, do not charge a person when things like these happen. So it's a difficult thing. I do not envy any one of the officers who would have had to make decisions in this. I also want to commend the officer from the DPP who took the matter from at the High Court stage, and also the juniors at the PI stage. They were very, very cooperative, and that's the reason why we got. Although for me it's a long time, 6 years and 9 months.
6 years and 9 months, and of course this crime would have taken place in 2017. Decision was made in 2023. Now tell us, why was the initial charge murder? For a case like this where one was abused continuously. At the time of the incident, the person, of course you can expound on it, the perpetrator at the time would have stated that he's going to kill her tonight, and then based on reflex or however it was, she had to defend herself, and as a result he was injured. So if you could just walk us through the circumstances in terms of some of the facts of this matter.
So my client was heavily involved into preaching, going out witnessing to people, and the deceased had some issues with her going out, and then made some accusations of her doing obia on him when she knelt to pray in a home, and from time to time that would transcend itself into physical abuse. There are a number of instances of physical abuse. In one instance, she got a domestic violence protection order from the court. And notwithstanding that order, the deceased would go to her home and at different times, and she would ask him to leave the home. He would, in some instances, and then a week, 2 weeks after, he would come back. Same type of behavior. Reports were made to the police. They would go, according to the evidence. Sometimes they would see him and speak to him. He would behave for a while. Sometimes the police would go to the place and would not see him and would not come out and look for him. So if he doesn't come out when they called, they wouldn't find him.
And of course, the police, just stick it up in, the police does not have legal authority to enter one's home to enforce entry, to ensure that they speak to
yes,
the alleged perpetrator.
There are particular circumstances in which they will give them a power to enter houses without a warrant. There are particular circumstances where they feel that life is in immediate danger. But in this instance, it was not his home. Remember, she built that home herself. In some instances, from the evidence, there was a lackadaisical search, and so it wasn't. There are instances when the police were very genuine, and it would vary with who would attend to the report. And other times, it was not so genuine, and they would just come and go. Or there may be instances where the police would have indicated that they are, to use the local jargon, they're fed up of coming because of the number of reports. But the cumulative effect of all these would be what was the result. And if we could go into the date in question. Now, there are a number of reports against him. There was also the protection order which expired. And on the date in question, where the abuse was, according to the evidence, almost 4 hours non-stop. And the witnesses were saying, had said to the police, and they had given written statements, that my client was bawling, help, help, call police, very, very loud. And there were also evidence that a neighbor saw the deceased who made my client lie on what they call the porch, and lie on her belly, his stomach, press his knees against her and beating her. And there was also evidence that
And that's a neighbor that witnessed.
Yes, and I'm talking about written statements. There are also other forms of abuse or physical abuse that period, that night. So it was torture for almost 4 hours. There's also evidence that the deceased drank a little alcohol and then threw the remaining alcohol from the bottle onto my client, and then was looking for match to light her. And she had to wash her eyes and run as far as she could see. There's also evidence that he stuck a knife on the door and said, you died tonight, you're dead tonight. So the evidence is clear, the evidence is glaring, it's compelling that the deceased was the aggressor that night. And he had been for quite a while. How it played off, very, very unfortunate. There are no winners in these sort of things. There are no winners. You have a life was lost, and a life was lost in tragic circumstances where the other life that was saved felt that if that was not done, it would have...
Either way, a life would have been lost that night. And of course, in terms of the act that was done, it was a matter of self-defense. When I note from the records, he was stabbed multiple times.
15 times. 15 times from the records.
And this was while he was attacking her?
Yes, there was no evidence that he stopped the attack. There was no evidence tendered that he stopped the attack. So it was while he was being attacked. As I said, it's difficult for the person on the other side making the decision to charge. When they're looking at the 15-star wounds, they say, well, how 15-star wounds, how we could account for that? But there was no evidence that it stopped. So as I said to the court, my client was entitled to defend herself until she felt safe. 15 stabs, so be it, because the beating never stopped, the abuse never stopped.
And at that time, she would have contacted the police?
Yes, because the deceased himself had forced her to call the police and say, call the police, call the police. And while she was talking to the police, the deceased made the call, remember. While she was talking to the police, he pulled down the phone, stopped the phone. So you could see the constant aggression, the constant abuse by the victim. I would say victim / deceased. And prior to the date and the amount that happened on that day, at the time of the incident, I think it was too much for any human being to take.
So the DPP had a difficult decision whether to free this individual or to charge her.
Yes.
They decided to charge her with murder at the first instance. Was it murder?
Yes, it was murder at the first instance. It was argued that I argued that my client should be discharged magistrate disagreed and committed for murder. So that's the position. You remember the thin line between self-defense and excessive force in law. There's a very thin line.
Yeah.
And there's also the concept of self-defense being exclusively for the jury to decide.
Yeah.
And if it has to reach a jury, it has to go to the High Court.
So this matter never got to a trial.
No.
Right. She was in pre-trial custody for a number of years. I said
yes.
6 years, 9 months.
Yes.
So what would have occurred between that length of time in terms of the progression of her court matter?
Right. So I had made application for bail after the Akil Charles matter. And I made an application for bail, and it is while the DPP officer, her name slipped me now, I think she might be Hella. We were discussing the bail and my grounds for the application, and she was saying that they were good grounds, and I had to it out to her, we can talk, meaning plea bargain. And then she said, well, that's a very good idea, and then we started that progress.
Now, why start the plea bargaining process so long after? Within at what year, what time was the plea bargaining process
started around about a year before the judgment, or less than that.
Okay, so that would have been, let's say, 5 years after the initial charge. So is it that at that time there were a lot of pre-trial preliminary inquiries and stuff?
Yes, you are quite correct.
Okay.
This was old-time committal.
Old-time committal.
Yeah.
Right.
So there was a lot of pre-trial issues and disclosure. And then I think too, in that period was the COVID. So that the COVID would have caused some delay too.
Right. So we're saying that you all had entered into discussions with relation to a plea bargaining. Tell me, why is it that you would have gone through or consented, well, your client consented to that plea bargaining procedure?
Well, I felt,
knowing fully well, at least there, but where I want to go is, what was the justification, what was her defense to the particular murder? I mean, of course, he said
yes,
self-defense.
quite frankly, let me tell you, I felt that if we were to go to trial, my client had a very, very, very good case of being freed. That's my feeling. There's no guarantee, but that was my feeling, right? But having said that, and having taken about this long time frame to reach the stage of PI, completion of the PI, not knowing when a trial will be set, right? And I've been discussing that with my client, and I put the options to her. And she said, yes, okay. You have my okay to talk. And so what prompted the plea bargain was the overall, my cognizance of the overall delay in instances like these after PI to committal to get a trial. So to serving of the indictment to full trial. So that I estimated that would have taken another 3 or 4 years. I may be wrong, but that was my estimate.
And our plea agreement laws have been, I know there was some revision, but in terms of the legislation for plea bargaining, that was already obviously instituted within the criminal procedure rules.
Yes. Mm-hmm. So the plea bargain was there, the offer was made. And
can you walk us through the procedure in terms of how the plea bargaining was negotiated?
So the procedure was when I applied for bail, and the judge, I also want to say I'm very, very happy with how the judge dealt with it. The judge kept it in the front burner. When I applied for bail, right, and the judge was pushing until the DPP filed the indictment. So that was very, very helpful because we discussed why deal with bail when we could deal with the entire thing once and for all. And so we got the indictment served, and then the process started, the process of the plea bargaining.
Now, you mentioned bail. Now, of course, many persons would ask, okay, you are charged with murder. why are you applying for bail? And I know there would have been developments in law,
Yes.
which we spoke about in previous incarnations of this program.
Yeah.
But I just want you to to give a outline of how it is that you arrived to apply for bail, or thought about applying for bail.
Because of the judgment of the Akil Charles matter, in which the Privy Council ruled that the court has a discretion to grant bail for murder. When I read that judgment, I took it up that I'll try a bail application. And the bail application, when it was filed, it appears that the officer or the DPP said that, hey, this is something that is crying out for justice, and we should deal with it urgently.
And the indictment, is it that the indictment was not filed before the preliminary stage, or indictment is only filed when the matter is now proceeding to trial?
Right, the indictment in this case was not filed. When I applied for the bail, the indictment was not filed. The judge instructed or directed, whatever the term you want to use, that the indictment file. I think the judge herself might have read through all the documents and see the injustice that has been done, or that has been done to my client.
So the indictment was filed, the plea bargaining was negotiated, where the agreement, you all came to an agreement. Can you walk us through what was the agreement that was,
right.
Was arrived at?
The agreement is, the starting point, the officer, the DPP, her name will come to me in a short while. I think Ms. Heller. Mm-hmm. They wanted to start at 12 years.
Yeah, I recall reading that.
12 years. So, but I got the distinct impression in the discussion that in the first set of discussions that they would not be pushing, when I say the DPP would not be pushing for a custodial sentence. So I took that to my client. At all stages of this process, I included my client. Yeah. So I would have gone back to the prison several times. So I took that to the client, and she said, okay. So I use a term. I'm not too worried about how you call it, but I just want my client to walk on that day, right? Time served, whatever you call it, but the agreement is if my client walks on that day, we free for that, we in for that. So we had those discussions, and in principle we agreed to certain things.
What was the plea that you agreed to?
A lesser count of manslaughter to start with, and then the starting position of sentencing of term would be 12, so that the DPP would agree to start at 12.
And why manslaughter? If you could just explain the elements of why.
Because the manslaughter was brought about by a series of acts that could provocation, self-defense, everything. A series of acts that would cause in law that the charge of murder be brought to manslaughter. Now, there's a little slight technicality which we did not deal much with, in that self-defense is always an issue for the jury, and for me, in my respective view, is a very, very thin line when self-defense shifts to excessive force, and therefore the person would no longer be, if it were to shift to excessive force, the person would no longer be entitled to the self-defense rule, and therefore the full murder. So it was a kind of mixture of all with a view of getting the matter heard with and dealt with, and getting the client to walk, given this injustice. So provocation / some sort of self-defense.
So provocation was so therefore the count was manslaughter with provocation.
Yes.
That was the defense at the time.
That's
a count of manslaughter. Yeah.
So that's how it ended up. So we back to where the agreed position. So I agreed to the 12 years with my learned friend on the other side, and then we started and then pretty aware of the discount, the time to be taken, and then some of the things would have contributed to more time being taken off would be that I think that my client had submitted, she had 27 courses while in custody over that period. Outstanding, she had an outstanding recommendation from the prison.
And the court would have taken into consideration a number of things, victim impact.
Yes.
They would have taken into consideration her time spent. Can you walk us through in terms of, I know that you indicated the starting point was 12 years.
Yes.
And then the court would have lowered his starting point.
Yes, the court's starting point was 6 years. The judge's starting point was 6 years, which I was very, very happy with.
Yes.
In fact, in the earlies, that would have been around the time I was looking at. But I give in because we had agreed on certain principles that my client would work on that date.
And then did she get further? Now I know with respect to the court, there's a case, is the Aguilera principle in terms of how the court looks at discounting
time spent.
Time spent.
Time spent must be counted and discounted. Full time spent. Full time spent. In fact, I think the court said an arithmetic formula in that case.
And therefore, after the 6 months starting, the court would have also taken into consideration her aggravating and mitigating circumstances to arrive at their decision. The court would have also taken into consideration the early plea entered.
Yes.
And the early plea entered, how much discount usually one gets when you
I think it's a full 1/3. Full 1/3 is discounted.
So it was a 1/3 discounted from the 6 years.
Yes.
That was the starting point. So now we're looking at about what, three years?
No, the 1/3 from the full 6 years plus our time server had to be counted.
Yes.
So we started with to use that term. We started off with a plus in terms of time spent.
So therefore, according to the court, and if I were just read in terms of a guilty plea, now what the court would have indicated is that a discount for a guilty plea was awarded in accordance with Terry Daly and the state, and this discount is usually 1/3.
Yes.
And what the court stated is that he found that the offender acknowledged and accepted responsibility for her unlawful conduct and that she pleaded guilty at the very earliest opportunity. And accordingly, she was entitled to the award of a usual discount of 1/3 of the guilty plea, and this brings the sentence to 4 years. And she would have spent 6 years, 9 months in pretrial custody, and therefore it means her time spent would have been more than what would have been sentenced.
Exactly so.
And as a result, your client was freed on that day?
On that day, yes. In fact, the judge gave on that day, and then he went on to give his written judgment sometime later.
Now, what was your reaction, though, to this sentencing decision delivered by Justice Henderson? And of course, as you said, I know you would have expected some outcome, but did you expect that particular outcome on that day?
Yes, I expected the outcome of my client walking on that day.
Okay.
I did not go into the full details of how it would be counted, but I expected the outcome of my client walking on that day. And when I finished addressing the court, I felt comfortable that I have done enough to convince the court. In fact, I felt very comfortable that I have done enough to convince the court to reach that position of my client walking in that day.
And what was your client's reaction? I mean,
indeed, it
lost
was
almost 7 years of your life.
She was elated that she would be out on that day, or she came out on the day, but she also told me when we were walking down the stairs, Mr. Ramkissoon, I did not intend to kill him. Those were her words, with tears in her eyes. And I remember giving the client a drop to near her house. There was no one to meet her outside the court. She has one child alive, and for some circumstances beyond the child's control, the child could not be there on that day. So I gave her a drop to near to where she lived. And another big problem in this scenario, while my client was in custody, her son was murdered while she was in custody, and she was not allowed to even view the funeral virtually, notwithstanding her application to do so to the prison's authority.
But why would one deny even a virtual, even allow a virtual view of a funeral when you are not incarcerated as a
Convicted
prisoner,
Yeah.
but rather incarcerated as in pre-trial custody.
That still baffles me. The prisoners have their rules, their policies, whether they are right or wrong. They exercise it until it's challenged.
And how long ago was that?
That was about 4 years ago while she was in custody.
And was it ever challenged?
No, it wasn't challenged. It was not challenged. But there was also that, around that time, I think there was also some little COVID issues, not the first set of COVID issues.
Yeah.
Right?
Well, I mean, it's virtual.
Yeah, but
sometimes you always wonder.
Yeah.
And of course, maintaining the human factor, in someone's flesh and blood passing away in certain circumstances and not being allowed for closure, that was probably very difficult.
That's a serious problem for me. I think that
was very difficult.
That would be her biggest hurt in this scenario.
And how did you, throughout the case, how did you ensure that her mental health and well-being were addressed, obviously given the nature of the case and the circumstances?
I visited her more often than I would do with any other prisoner. I go, other prisoners you might get once or two times and take instructions when you get statements and those sort of things. But I visited her more, I realized more and more she was attending to the services that were offered at the prison, which I encouraged her to do. And she was seeing results from those services.
To keep your mind occupied.
Yes.
And how old was she? How old was she when she committed the offense?
I think it was 49 or 47.
Okay, so she would have been quite advanced in terms of she's almost at, and she's now in her 50s,
I spoke to her recently, and she said she's starting a new business, and she is doing okay.
I was hoping for her to come on the show, but I know in these circumstances it's hard to relive certain situations, and sometimes persons get a bit of a fright, right?
But I think it's a genuine fear and a genuine emotional problem, because she indicated to me that she went to a forum organized by a community-spirited group somewhere to talk about DV against women, and she promised them she went, and she just couldn't go on the stage.
Yeah, it's difficult, and you have to allow that grace.
Yeah.
Now let's turn to the justice system.
Yes.
How would you assess the handling of this case by the justice system, especially many factors regarding the amount of time spent? Let's first start with the amount of time spent in pretrial custody.
I think a case like this shouldn't take so long with pretrial issues. But as I say, it's easy for one who is not in the system to make the decision to say, but there is the counter cry of the large number of cases that have to be dealt with. Whether you can develop a system where you can sort of compartmentalize these types of cases, I think that would be very good if you can develop that system and deal with those quickly. But then there's the other side to it. Everyone will cry that his case is more important. His case, his liberty is also important.
Yeah.
So how do you strike that balance in the public domain? It's a difficult thing. But there should be some system where you can pull cases like these out and deal with it quickly.
I know, and the most important aspect is that Justice Henderson would have discussed or admonished the role of the police and the community. He mentioned that the role of the neighbors and the community failed both victims. So therefore, how do you think that the community and law enforcement can handle better situations, similar situations like this?
Well, the community and law enforcement handle better situations by first, and it's no secret, in recent times there have been outcries of the lack of public confidence and trust in the police, in the TTPS. Mm-hmm. The first step would be to start to develop that, the public trust and confidence in police. And the other aspect of the public the police going into the communities and developing these links. Personnel from the TTPS would go into the villages and develop contacts and get these communities together to to work in tandem with the police. The police have been advocating that there has been a tremendous success with their youth group
the
concept.
police youth group, yes. I have been part of police youth group before. I've formed police youth groups. But community policing, is it that, because what I've noticed is that even being involved, that the community police sometimes lack a lot of resources, a lot of manpower to actually get involved because the officers are limited. Most community police units, they have one vehicle, right? Or sometimes two vehicles. And then too, there's so many different issues. Community policing should be, while it's a unit, officers should be recruited for the purpose of community policing.
Yeah, there should be a special skill.
Because I believe that, and this is just a personal view, that community police should also involve psychiatric training, psychology training, counsel training, and therefore these officers should be sent to training in order to properly understand or properly effect their service of community policing, and not just policing from an aspect of law enforcement.
Yes.
Because there are a lot of variables. There's social issues, economic issues, psychology issues, and I believe they are stretched.
Well, I do not know, I have not read any document in recent times with the development in terms of the training of the community police officers. But I would expect that training will change to meet the needs of the society which the organization is servicing. Having said that, I am in full agreement with you that training is and must be an essential part of the community policing. It has to be, there's no other way. When you develop that link, you see almost everything in the villages, in the towns, and then into the cities. There are areas where there were, in the past, I know, very, very good community police officers develop skill, notwithstanding the lack of vehicles. Because if you have a community officer who has developed a good rapport, as we say, with the public, and you want to move from point A to point B, he just calls a part and get it done. I do not know if they are doing it in a structured way when I say that is the community policing, or how they have it at station, and what is the mandate, who is really reviewing or appraising the system for the quality of work done, right? And the success of the work that has been done.
Yeah. And even Justice Henderson, and I'd like to just review paragraph 39 of his judgment.
To look at that, and that is about the most telling part of this in my respectful view, of this whole case. Yeah. Apart, of course, the first two paragraphs that you read, when there are two victims which institutions have failed. It is this paragraph,
and if we could just go through that particular.
We're talking about paragraph
39 of his particular observations. I know it started from paragraph 38. Yeah. For the viewers and listeners, we are reviewing the judgment of Justice Henderson in this matter.
So I'll start by paragraph 38, and I'm quoting. Before concluding, the court feels compelled to make the following observations. There is little dispute that intimate partner violence is a significant public health issue in our country that results in significant and devastating individual loss, as this case has shown. It has shattered the lives of two families, that of the offender, the death of the deceased, and from the victim impact statement, has compromised the education of the surviving child of the deceased. It also carries significant cost to taxpayers, as these cases show. End of quote. So this is telling us just exactly as we started. Yes. Two families were impacted, and the tremendous problem, not only to my client, but also to the victim. He had a child, and whose education would have been affected by this. Yeah. So the judge has said it very, very clear, and I continue at paragraph 39, quote, intimate partner violence is preventable and the outcome of this case should not have happened. There were clear signs that were ignored, and had that not been the case, it may well have been that this violence could have been prevented. While I accept frustration of police officers in these types of cases where abuse partners keep returning to their abusers only to report them once again, the Trinidad and Tobago Police Service has failed both victims as they neither served nor protected them. End of quote. So just as we are saying, it is clear, it may sound critical of the police, but it was the situation then. There are many cries that many situations like this remain up to today. And we cannot bury our heads in the sand to say things are improving when a judge is saying, giving this in writing.
Recently, that's just as recent as November 2023.
Based on the evidence presented to him.
Yep.
I would hope that, and I would read further, I would hope that this judgment had reached the commissioner and pass on to the various authorities. I know there is a gender-based unit.
Yeah.
And that they may, notwithstanding their claim of lack of resources, prioritize some of your resources to point in this area to prevent this sort of statement being made again by a judge.
Yeah.
And I might add, this statement in these circumstances was rightfully made or correctly made.
Yeah.
That's how it is. And if you will continue, and I continue to quote, while the social services in ARIMA referred to by the client may or may not have been appropriate agency to help with the abusive relationship, a whole of government approach should have been put in her contact with the appropriate resource and funded agencies that would. The neighbors of these two victims failed them. Rather than simply, inverted commas, marco what was happening, it is clear that no one attempted to intervene, in the very least, to call the police.
And that is striking.
End of quote.
And that shows the sensitivity or insensitivity of our community now.
Yes.
In that person's like, not my party, not my function,
yes.
Therefore, I will just look the other way.
Yes.
And of course, this is, I mean, if we look at long time scenario whereby a neighbor will get involved,
yes.
Now persons are just, and I don't know if it's because of the fact that persons are now protecting themselves,
yes.
and are afraid of reprisal or afraid of being
yes.
of being the victim.
Yes.
They have now decided to retort to not knowing or not seeing.
Yes.
And that is unfortunate.
To me, it's very, very unfortunate that a village like this, that this part would happen. It is extremely unfortunate.
Particularly in a community that is not, it's a village.
Yes.
It's an area, to me, because you would find more villages where everyone know one another, the neighbors, their brothers, keepers, versus communities which are more on the gated side and stuff. Everybody mind their business, nobody says hello, whatever. So you would have expected that a village like that may have had some better understanding in terms of community spirit.
Yes.
But then again, even part of the evidence, one of the neighbors went outside, was looking, came inside, spoke to her husband, and then they decided, well, we're not going to call the police. And that person would have put that in her statement.
Yes, the person put that in a statement. So it baffles everyone that something like this would happen and someone would not call the police. It defies logic. I can understand in these circumstances, in the present time, with how the people are afraid to get involved, as they say. The public, there may be a reason for this, the public trust and confidence in the police service when reports are made. In terms of confidentiality, people may be afraid. That is no secret, that is public knowledge now.
Yeah.
So that may be a factor. I am speculating. So I'm really I do not like it. I do not like how this happened. I would, for a small village, I would have never expected this to happen in this way.
And we really hope that at least that there will be lessons learned. It is trust that there are lessons learned. I'm not sure if, I know the judge did direct that this case or this judgment be delivered to the Commissioner of Police for deliberation, etc.
Yeah, I propose to read that part also. Yeah. Yes, and I know I took it upon myself when I got this judgment to speak to 2 senior officers about the judgment and what the judge had to say. Very senior officers. And they promised that they will look into it. Because I have a sort of good rapport with some of the senior officers on judgment. And I'll tell you, at this point, this DV was something that is close to me. I've been dealing with this for quite a while. And I had done a training manual / program for the United Nations on the Spotlight Initiative. Entire training program for, I think it would have been used for the TTPS. Since I prepared it, I have not followed up on the outcome, whether it was delivered in terms of the training programs. And so it is kind of close to me. And when you have to deal with situations like this, in which there is strong evidence of the things said here, extremely strong evidence, you wonder what is the society going to? How do we build trust and confidence in the police service to a point where people will feel confident to bring information, call, and they will not be fearful that it will reach the wrong hands and things like that.
And then also the justice system as well.
Yeah.
Because we have seen where partners who are the recipients of protection orders,
yes.
Sometimes even when the protection orders are breached by the person who the protection order is against, when they make the report to the police, sometimes it's not actioned, and therefore it may be a point in time where you have to go back to your attorneys, have to refile an action before the court, and all these different things.
Yes, that is so.
So a piece of paper in terms of protection order, we have seen even recently, I believe there's so many matters out there that persons will be recipients of protection orders, and it is breached time and time again.
Yes, so
without any recourse or without, yeah.
You see, sometimes, and when you say they become upset, the police take the easy way out. They don't want to, they try to convince the holder of the order not to proceed. They want to take the easy way out. It's factual. And yes, we may get some criticism for saying that, but it is so. You're right. You have the protection order being breached, and they go to the station. Sometimes they just write, the police officer take the report in their personal diary because they may have to come to court and those take statements and those things. And you're also right. First thing they want to do is send you back to your attorney when the order has been breached, and there is no need for the attorney to come in.
Because it's instructive. It is now a criminal matter.
Yes.
A
prosecution case.
Yeah.
So, but the shifting and
the shifting of the goalposts always. Again, of course, with all due respect to the TTPS, of course, there are numerous officers who I know personally who have had the opportunity to really work hard towards reducing such violent occurrence. But then that is just a number, which. A small number, and then when you have a large number that outweighs the small number, it becomes frustrated because then you feel as though your actions are falling on deaf ears when it comes to the next stage.
Yes, and there would be there are officers who take their job very, very seriously and do everything and follow it up to the end. And these officers, when they see, they would say to me when they see the other officers not doing their job and no action being taken against them, it leaves them to a point of, what am I going through all this for?
Yeah.
But it's the level of professionalism by the officer that cause them to exhibit this type of behavior. So you have to constantly train And one of the biggest problems, which you may not be able to train, is attitude.
Yeah.
So
that's another discussion.
Yeah.
But of course, you know, your client, Miss L, she's out. You stated that she has now reintegrated into society, because sometimes integration is a next stage where they need assistance in that reintegrative aspect of society.
She has started,
and you said she has started a business.
A small business. She had informed me yesterday.
That is excellent. That is excellent. So is there any other thing that you want to share about the case, your experience representing, or any message for viewers listeners who may find themselves in similar situations?
The similar situation, if people were to find themselves in similar situation, and they are talking about both male and female persons who are abused, I'm not only female abuse. Just go make the reports and ask to see senior officers. Make sure your reports are recorded, make sure your reports are dealt with, and you get the action that is required in law. But having said that, you also have to take some measures to protect yourself. So how you would do that would be based on the circumstances in which you are, where you find yourself, and avoidance in most cases would be the most appropriate action to take. But insist on the service providers, right, to provide you the services that they are paid for. Just they must go up the rank. I usually go up the rank. Access to the corporal, the sergeant, the inspector, so on. So you are a victim. The state demands that the TTPSC help you. When you go to make your report, don't just get frustrated and give up. I know it's easy for a person who is not abused to say those things, but you are to take charge of your situation.
Yeah, agreed. And make your reports, collect your receipts, and just continue pressing. Get an attorney. Of course, if you can't, if you can't afford one, there's access to legal aid. So there's access to justice. But of course, you know, all parties have to become part of this process.
Yeah, you may want to find yourself contacting the newly formed gender-based violence unit.
Yes, and the head of the gender-based violence unit was here at our first program, Miss Craig Ireland, who I mean, I've had discussions with her, and she remains accessible. But of course, she's just one person, you know, and you know, it's important to have all hands on deck, including being our brother's keeper in this process.
She has been very, very cooperative. Anytime I would call in such instances as this.
Right, so Mr. Ramkissoon, it's a wrap, of course, and you know, I want to thank you sincerely for being on the program. I'm not sure if you have any closing words to state.
I want to thank you for having me, and I just want to repeat what I said in the beginning. There are no winners to this case. Families have been affected, and families will be affected for the rest of their lives. And we all have a duty to try to prevent instances of this. We all have a duty to stand up with people, victims in these circumstances, and assist, even if it means going to the police station with them, or writing a letter on their behalf, or making a call on their behalf. It's only by our collective efforts we would see results. Results that we need, results that we deserve, to make a better Trinidad and Tobago.
Right, to make a better Trinidad and Tobago. Thank you so much, Mr. Ramkissoon, and all the best to you, all the best to your client. Please give her our regards, and hope that she continues to protect her mental health and be safe. Thank you. So guys, it's a wrap. You have been watching Strictly Legal on WESN Content Capital. I am Rondell Donawa. Join us next time as we continue the series highlighting gender-based violence and other related issues. Of course, I will leave you with this quote: "There's always light, if only we're brave enough to see it, if only we're brave enough to be it." Enjoy your day. God bless.